Hello, everyone. Welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch. I'm kicking it off with 2 updates. Brink is back. And then, oh rats, another remand. I hope you like it. Court with Krissy is now in session.
Next matter is the State of Michigan versus Chelsea Brink. It's file 25-43824-SM, set for a status conference. I do see Ms. Brink is here. Mr. Brown is here as well. Do we have a resolution of this matter, Mr. Brown?
We do not, Your Honor. This is a trespass case. As far as I know, there hasn't been any offer in the matter. However, I did speak with Ms. Brink, and it that we didn't really get into the facts of the case. She wants to set this matter for a trial.
Is that accurate, Ms. Brink?
Yes, it is, Your Honor.
All right. What we're going to do is we'll have this set for a one-day trial, gentlemen. Is that going to be sufficient?
More than, yeah.
Yes, Judge.
All right. Prior to the trial, we'll need criminal jury instructions as agreed upon by the counsel. If there's something that's not agreed upon, it'll have to be taken up at the hearing at the last final status conference. So 1 set of criminal jury instructions, exchange, witness and exhibit lists within 30 days. Evidentiary motions filed within 30 days and heard on the day for the final status conference, and a final status conference 1 week in advance to make sure that we're ready to go to proceed to the trial. Ms. Brink, setting a trial means that you're going to need to be in contact with your attorney because there are a lot of things that he needs to talk to you about prior to the trial. So I'm going to set a status conference just like this 1 week in advance to make sure that everything is ready to go for the trial the following week, which means that I want you to have lots of contact with Mr. Brown before that status conference. Don't wait for the status conference. Don't wait for that final week to try to get ready. Make sure that you're ready to talk to him ahead of time so that he knows all of your concerns and he can talk to you about all of the legal issues that come up with a jury trial. There's lots of moving parts at a jury trial, not only with the jurors, but with the legal issues that come up prior to that. And I want to have as many issues ironed out ahead of time so that you can make a good decision about whether it still makes sense to have a jury trial before we actually have to bring in all of the jurors. I don't want to have them waiting and sitting around while you're trying to decide what to do. Does that make sense?
Yes, sir. Thank you.
All right. Any other questions that you have, Ms. Brink?
So if I'm understanding you correctly, there's going to be 2 court hearings, a status conference 1 week prior to the jury trial, correct?
Correct. And we'll send you out notices of when that is. I don't know when that is right yet because I don't control the docket. I don't have the calendar in front of me. So we're going to mail you a notice of when the jury trial is going to be, and 1 week in advance of that, we'll have a status conference just like this over Zoom. The jury trial will be in person, so you'll have to come to court for the jury trial. The status conference will be via Zoom, just like you're doing today.
Sure. And then, so I'm sorry, hang on, let me write this down real quick.
Yep, go ahead.
For the trial, is that going to be in the district courtroom or the?
Correct.
Okay. Okay, I think that answers all my questions, Your Honor.
All right. As long as you get a hold of your attorney quickly and stay in good contact with him, we should be good. All right. That's all for today.
Yes,
Thank you.
Thank you.
You're welcome.
Yeah, it was just today. She just put that in. It was for a district court pretrial on August 12th. And now he's scheduled for sentencing, so we don't need to see him, Mr. Hubble.
Okay, thank you.
Yes, sir. May I have your name, please?
Jessica Lambie.
Good afternoon, Ms. Lambie. We're on the record in case number 24-2281FY. You're appearing for a bench warrant arraignment this afternoon. You're appearing with Mr. Hubble, the defense attorney available through the Indigent Defense Counsel here to assist you with that arraignment. He's not yet had an opportunity to speak with you, so I'm going to place you and Mr. Hubble in a breakout room so that he could go over the issues regarding the bench warrant with you before we get back on the record.
Okay.
Thank you. So we're back on the record in case number 24-2281. FY, and Mr. Hubble, you had opportunity to review the allegations on the bench warrant nature of the same with Ms. Lambie.
I have, Your Honor. She understands she's got the right to request a hearing in front of the judge with the assistance of her attorney, Sean Warden. She wants to waive that, take responsibility for failing to show up, but she'd like the court to consider her explanation for what happened and what she did about it.
No, sir. So for right now, Mr. Hubble, this was a fail to appear for sentencing. So she's going to be remanded to jail until the time that she can see the judge, and she can explain then to the judge why it is that she failed to appear.
She did appear a half an hour late. She took the wrong bus. She did report to the court. There should be information in the court files showing that she did appear. She also went to her attorney's office to try and resolve the matter and wasn't able to talk to him. So she'll explain all that to the judge when she sees the judge. Do you know when that might happen, Your Honor?
I do not know. We will get the file to the judge. It's a Judge Cooney case, so I'll get the file to him immediately. I don't know when it is that he would be able to see Ms. Lambie.
So just tell the judge that, okay, Jessica?
Okay.
So for right now, Ms. Lambie, you are all set. We will get the file to the judge. He will see you as soon as he is able to see you to accept that plea.
Is there a way to ask for expedited?
You know, the judge is aware that you're incarcerated and he will see you as soon as he is able.
That way, because I have my final housing inspection on Thursday.
Okay, but for right now, ma'am, you are all set.
Saki, are you able to hear me? There we go. All right. Is that Ms. Ernst we have over there?
It is.
Yes.
All right. We'll first take up the case of 2025-11374-PH. Just for the record, I'm Judge Wiggins in the 84th District Court in Wexford County, sitting by assignment for the 84th District Court in Missaukee County. And this case in particular is an alleged violation of a personal protection order. It is alleged that the defendant engaged in stalking activity by yelling names at the petitioner and calling that petitioner by name, also threw a can at the petitioner. The court, through Judge Ransom, had issued the personal protection order back on, looks like April 1st, and there is a proof of service in the file. Ms. Ernst, you do have the right to have a contested hearing in this matter. If you are found guilty of the violation, you could be sentenced up to 93 days in jail and or a fine of $500. You also have the right to be represented by an attorney throughout this process. And if you wanted to be represented by an attorney but could not afford one, the court would appoint one to represent you, but you may have to repay a portion of that expense. Do you understand that?
Yes, sir.
All right. So my first question to you is do you wish to hire an attorney, represent yourself, or request the appointment of an attorney?
Can you help me with that, sir? I don't understand. I don't understand law language, sir. I don't understand what he's saying.
Your Honor, she's requesting the appointment of an attorney.
All right. The court will make a referral for an appointment of an attorney. Mr. Champion, have you had the opportunity to discuss the issue with her?
I have, but I do not have an answer in this matter.
All right, so do you want it set for a contested hearing then?
Please.
All right, court will set the matter for a contested hearing. We'll come back to bond in a moment, and that brings us to the new file of 25877 FY, the people of the state of Michigan versus Karina Marie Ernst. Mr. Champion, were you aware of this file as well?
I was, Your Honor.
All right. And did you have the opportunity to meet with her regarding this case then?
I have, Your Honor.
All right. Ms. Ernst, I have a complaint that alleges that on or about August 16th of 2025 in Clam Union Township of Missaukee County, it is alleged that you did commit the offense in count number 1 of police officer assaulting, resisting, or obstructing officer or deputy Vorpragel. That is a 2-year felony and or a fine of $2,000. And it's possible that consecutive sentencing may apply if this happened in a place of confinement. The prosecution has also elected to charge you as a habitual second offender. That means that you have at least, or you have one prior either attempted or completed felony in your past. That makes that 2-year felony punishable by up to 3 years. Do you understand those charges and the potential penalties?
Mr. Champion, my client is electing to maintain her silence at this point in time.
All right. Ms. Ernst, the court will note that you stand mute at this time. Now, my next question for you is,
How do I show their false accusations? Well, you have to let him know they're false accusations. That's the only thing I'm saying about it. I have the right to counterreact that. Those are false accusations, sir. I have the right to counterreact that. That's all I got to say. That's all I got to say about it.
I understand your position. I just don't want you to say anything further about the case because I don't want you to make any statements that can be used against you. Now, on
I have to make sure I say that in my defense, right? Yeah.
On felony
complaint. Okay.
Ms. Ernst, on felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions. You also have the right to have an attorney represent you in this matter, and if you could not afford one, one would be appointed to represent you. Well, first of all, Mr. Ernst, do you understand that?
Am I being placed under arrest again?
No.
No, okay, all right. Yes, ma'am, or sir, I understand that.
You understand that those are your rights?
Is he put me under arrest again?
No, I'm not putting you under arrest.
Yeah, I understand that what do they call that, the Miranda? Are we learning the Miranda in this? Is it called the Miranda?
It's close to Miranda, but it's not entirely there. Mr. Champion, are you seeking an appointment in this case as well?
I am, Your Honor.
All right. The court will make the referral for the appointment of an attorney. Again, I'll note that the defendant stands mute and will mark this for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the offense had occurred, and 2, probable cause that Ms. Ernst was the person who had committed the offense. If the prosecution is not able to do that, the case will be dismissed. If they are able to do that, Ms. Ernst will be ordered to stand trial in circuit court. Regarding bond counsel, I show in 2024 the attempted resist and obstruct and a retail fraud second. It's my understanding that bond was set in this case at $10,000 over the weekend. And then in the personal protection violation, there was a remand. Any comment regarding bond, Mr. Champion?
And I'm going to be requesting a forensic exam. Does the court want to take that motion now, or does the court wish me to file a written motion on that?
Given that it's not, that I'm substituting in, I would prefer that you do a written motion.
With that, Your Honor, my client does reside in the area. She has a limited criminal history, as the court is aware in this matter. I would ask the court to consider a PR bond.
Thank you. Mr. Ringstrom, on behalf of the people?
Yes, Your Honor. Although she might not be a risk to the community as a whole, she does seem to be a risk to the neighborhood that she is in. She obviously, or I should say, she's accused of obviously not being able to follow orders as is. There is some question as far as if she were released, how much more violations she might stack up. So we would ask for a bond in this. People are not opposed to lowering it from the $10,000 necessarily. However, we do believe that there should be some monetary bond to be able to make sure that she complies.
What was the nature of the resist and obstruct?
It really, the nature is not like violent at all or anything like that. At that time, the officer, the allegations are that the officer told her, "You're under arrest for the PPO violation." She turned and started running from the officer, and he had to go get her and all of that stuff. So it wasn't necessarily violent. It wasn't anything along that lines, but she was running away from the officer.
All right, thank you. Mr. Champion, are you aware, is your client a client of community mental health at all?
She is not, Your Honor. It's my understanding she does not participate with CMH.
All right. Well, given that the defendant was a subject of a personal protection order, at least as alleged, she'd violated that protection order, and the fact that she tried to run from police while they tried to apprehend her for that violation, I do find that she is a flight risk.
In a sense, in a kind of moves rights or not rights for others. I fell out of the system. I can't get medical attention right now, but I'll look at it in 5 years. I'll try to get back up in there for rights or not rights. I'm part of the Salvation Army, okay? But it's like a tool. I'm supposed to hold on to mine, and I lost you for like 5 years, so I'll try to get up there in 5 years and see what I can do. Okay.
I understand.
All right.
I'm going to keep bond where it was previously set at $10,000 cash surety. I'm going to order that the defendant appears ordered, keep her contact information current, not leave the state without permission, and to commit no new crimes. And in the personal protection violation, the court will continue the remand in that case. Anything else, counsel?
No, Your Honor.
No,
Thank
Your
you.
Honor.
Thank you. Thank you, Misaki.
That's what I need to know.
Step up right here, take a point for the judge.
Levi William Camp.
Okay, sir.
How are you, Judge Carter? It's been a while.
Yes, it has been. I'm fine, thank you.
I've actually done great in my life up until this little incident.
Okay. Well, we're going to be talking about the little incident here in a moment.
Yes, sir.
All right, sir. Your address is still on Brink.
Brand new phone number. It's all good numbers for me.
Okay. So you have 2 warrants for your arrest, and then you also have new charges. I'm going to talk about the warrants first.
Okay.
The warrants were, one of them was on case number 2022 CM 12115, and that's failure to pay fines on a false reporting incident that occurred in 2022. That has a balance of $357.30 left on it.
Okay.
Yeah, the second case is 2017 CR 12398. That's a 2017 case, and that's failure to pay fines on a criminal damage case, and a lot of that has to do with restitution, so somebody's owed that money. All right, so that's the 2 warrants that we have for you. I've scheduled you for a court date to do a warrant review on the 22nd. The bond that I've posted on those both of those court dates. No, you are interrupting.
Okay, good.
So I don't care what you mean, but you are. So I'll give you a chance to be heard, but I got to go through these things. So I'm going to listen to what you have to say, but I'm going to go through these portions, okay? The one that has a victim that's involved, that's owed restitution, there's a $300 cash-only bond That's required. The other case, the false information, I've lowered that to $10 so I can give you credit for time served if you don't come up with the other $300. So what that means is if you stay in custody all the way to August 22nd, I'm going to take some fines off of that other charge. I can't reduce the restitution. Okay, so that's just the warrants. Now we're going to talk about the current charges. Those charges are possession of or use of a dangerous drug and possession or use of drug paraphernalia. On those charges, you have the right to remain silent, right to counsel, and right to trial. I scheduled you for a preliminary hearing on the 22nd of August at 3:00 p.m. The preliminary hearing is to determine if there's probable cause to charge you with those felonies or not convict you. If there is probable cause, the case will bind over to the Gila County Superior Court. If there's not probable cause, those cases could be dismissed. Your release conditions on those charges are obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not possess or consume any alcohol or drugs without a valid prescription, and do not possess any firearms, because it's a felony allegation. If you're convicted, you could become a prohibited possessor. Now, you wanted to eagerly tell me something, so I'm going to give you a moment to talk to me now.
Yes, sir. First, foremost, I'm sorry for having seen you again after all these years. I tried to change my life. I did change my life, and I have a good job now. I worked several times, and I'm going to lose this job if I have to stay in custody, sir. And I'm able to see my son now after reevaluating my life. The drug, what I was caught with was just mushrooms. It wasn't meth and nothing like that. I'm really been trying to change my life, sir. I really have, and I did. I successfully did. I haven't used any kind of meth, fentanyl, nothing like that for over 2 years. I'm really trying, sir, and this is going to derail me 100%. Anything I could do, work release, pre-trial services, anything. I get paid on Monday. I'll pay off the full balance of both of them. I get paid on Monday. I have to go to work, sir.
Okay, but you don't know even what the balance is on the $300 bond one, do you?
It's like $2,000, something like that, I think.
It's $1,103, so $1,103, and then the other one has a balance of $357.
I could pay that on Monday.
Well, here's the deal: you're getting your paycheck on Monday. Is that what your deal is?
Yes, sir.
Well, so that could have been paid a long time ago.
I know, and I was.
So what's inspiring you to pay it now is your threat of loss of liberty.
My daughter, my son.
Right. So that's what's causing you to want to pay it now. It would have been good to have that same reasoning without you getting caught and put into jail, that you just wanted to clear that. So that wasn't there prior to you getting in jail. So to release yourself out of jail is what you're trying to convince me of, that you'll pay the whole thing. But here's the deal.
My brother paid $100 this morning on it.
Okay, here's the deal, is you've promised to make a very reasonable monthly payment already to me or another judge. And not only are they fines that you're related to the court, but most importantly, there's a victim that is owed restitution. I wish I could have them in here to hear your pleading to see if they would accept it. I would listen to what they had. Hold on a minute. Instead of not listening to what I'm telling you, because you're so eager to tell me and throw upon me your will of how you want to be let out because your life's going to be ruined, I want you to think someone else besides yourself. Don't think of yourself. Think of the person that you owe money to, that you've been convicted of a crime, and that you owe a victim, because right now you just told me that you'd pay the whole thing. Okay? That victim would be satisfied with that. I don't believe you. I don't believe you for one moment, because the minimum fine that you were allowed to pay before I'm talking to you with the threat of the loss of your liberty, you didn't make that minimum payment, and you haven't made it for quite a while. So you're throwing all this at me to try to sympathize with you when there's a victim over there that's been waiting to be paid for the crimes that you committed, and reimburse them. I'm thinking of that person. I'm not thinking of you. I'm not thinking of you.
I understand, sir, and I'm just thinking of, you are right. I was under the threat of loss of liberty and everything, yes. It has made me reevaluate what is important because I wasn't taking it seriously. Now I am, and my brother paid $100 this morning. I could pay another payment if I am released. I walk right to the courthouse and do it, and then that's $200 today, and then I can pay the rest on Monday.
All right, so what I'm going to do is give you an opportunity. I'm not releasing you, but I was going to post $1,000 bond additional on the new charges that you had, the paraphernalia and the possession of the dangerous drug. I'm going to release you on your own recognizance. The only victim in those cases is you. So I'm still thinking of the other victim. The only one on that one is you're doing damage to yourself by committing those crimes. I'm going to release you on your own recognizance on those, but the $300 bond will remain in place, and so will the $10. So $310 will get you released out of custody. Now you told me.
I have that paid today. Can I not be transferred until I have that paid?
Yeah, if you have the intentions to pay that, let the detention staff know, and they'll make the arrangements to where you can have it done.
Oh, but can I get a phone number out of my phone?
You'll have to discuss that with them. I'm not in charge of the jail. Okay. All right, so that's what we'll do is I'm going to release you. I'm going to give you a new court date on the felony charges. You must appear on that, okay? Absolutely. So it's not the 22nd like I told you. It's going to be later. Call a day ahead of time still to find out about that.
Yes, sir.
After you make these payments, now you told me I can pay it all on Monday, so I'm at least wanting to look at that one case that has the $1,100 balance owed. That victim gets taken care of, and then the rest of it we can discuss back on the payment plan any time that's needed to be served. But then you have these other charges. These are only allegations of the felonies that they're going to be coming. So I'm giving you an opportunity. Okay.
Is there any bail bondsmen that will work in town? If not,
these are not bail bonds eligible. They're cash for fines. Yeah, because because bail bonds, the victim doesn't get paid that way.
Okay.
These are cash, yeah, okay. It's $310, so.
Yeah, I'm sure I can have that here.
Okay, let me give you the new court date. Give me a second here. It'll be September 2nd on that other felony one, so you'll have to call the Friday before.
Yes, sir.
Because the 1st is a holiday. So you have, if you don't post the bond of the $310, that'll be the August 22nd. I'll see you on that date. If you do post it, you'll be released, and then you just got to make your payment plan and do what you were doing before. On the new felony charges, September 2nd of 2025 at 3:00 p.m. is that preliminary hearing date. Do you have any questions on any of that information?
No, sir, and I appreciate you working with me.
Well, you can appreciate me working with you by paying the victim off. Then I'll actually give you some credit to what you're saying.
Yes, sir.
Okay? You have any questions?
No, sir.
All right, that's all I got.